Hi, it's Harry Fine again. It's December 2nd, 2025, and the Ontario provincial government has recently passed Bill 60. Bill 60 is an omnibus bill, and it affected many issues related to development and construction, but it also included some provisions that changed the Residential Tenancies Act, and today we're going to learn about them. I know many of you, you probably know I am a paralegal, no longer taking clients. I do a lot of training to institutional landlords. I do a lot of training over the years to brokerages and to boards. I'm a former adjudicator at the LTB, but now in a very semi-retired life, but I still love my teaching and my online form materials and my online training packages that you could get at landlordtraining.ca, but that's, I guess, the last plug I'll give, except to remember to go to landlordtraining.ca. I've done a quick PowerPoint to give you the highlights of Bill 60, so without further introduction, let me go ahead and say this is not legal advice. This is provided for educational purposes only. The things you need to know about Bill 60 is why we have it, why the government even created it. And of course, the news you're seeing and hearing on radio and TV is it's an attack on tenants' rights. And is it really an attack on tenants' rights? What's in the bill? And is it as bad as tenants say, or is it as good as some landlords think? Oh my goodness, I hear things from landlords, oh, this is a whole new day for us. I mean, the government is saying, oh, people are going to get back into doing rentals. So is any of that make any sense? A lot of stuff is dealt with by regulations, so we're going to talk about what regulations are and why they're important and the fact that they don't exist yet. What the government still has to do before it's in force, and a little guess on when it will be ready. So Bill 60 was an omnibus bill, which means it contained many, many things, and the government often slides things into omnibus bills. And it received third reading on November 24, and just a few days ago, it got Royal Assent, meaning the Queen's representative in Canada, signed off and said this can become law. The government's purpose is to speed things up because they're getting so much bad press, rightfully so. Delays at the LTB, landlords complaining, tenants complaining, and they need to do something. And they've tried to do lots of things. They've hired so many adjudicators in the last 3 years, but it still doesn't seem to matter. They've gotten rid of the COVID backlog, but there's still delay. And in fact, I did read somewhere that this past year they had their record number of applications, 100,000 and something. So even though they've managed to, bite away into the COVID issue because they were closed for 5 months during COVID, they still are at a point that is unacceptable, and it's still, they're trying to find ways to reduce that delay. There are a lot of things that cause the delay. A lot of them are process related, and those are the things that are being addressed in the bill. It's about process. They want to tighten up some of the things that cause delays because of process, not so much the law, but how things are dealt with in hearings. And in many cases, the delays are caused because processes and decisions that have become normalized over time because adjudicators learn from other adjudicators and they've learned from other adjudicators. So things sort of start becoming the way they are. And I think part of Bill 60 is about saying, hey, let's reset the clock on some of this. The Premier is also introduced the bill and changing the law because he's getting a lot of flack from his own base. And if you hear the government's spin on this, they're saying, wow, this is one of our key efforts in our housing plan because by amending the RTA, we're going to encourage a lot of landlords who might have been on the fence, maybe they used to be in the landlord business, to once again become landlords. I don't think it will do any of that. When this whole process started around 3 months ago, and it's been fast, there were no public hearings. There was talk about a change to the RTA that would have the end to perpetual tenancies where they simply become month to month forever. That would certainly be for landlords the holy grail. I don't think that was ever supposed to happen. I think it was something they threw out there. They wanted to test the water. They wanted to be able to back off on that and say that they're not doing that. But certainly one of the biggest reasons that landlords are afraid to rent is because truly, once you rent to a tenant, unless you evict for one of the no-fault applications, you might have a tenant that is there forever, 10 years, 20 years. Tenancies don't end in Ontario, and that's an issue, that there's no such thing as a fixed term, an absolute fixed short-term tenancy. So this is not about bad tenants or bad landlords or good tenants or good landlords, because there's enough of both. This is about the facts as I've investigated them and researched them, but it's hardly an attack on tenants. The tenant advocacy groups have done a wonderful job of trying to get the government to reconsider some of these provisions. It is not very normal for changes to the RTA to go the landlord's way, and tenant groups aren't used to it. And I think they're sort of shocked that something actually pushed back towards the right, I guess I can say. And they've been very impressive, but there was no way in this majority government, without public hearings, that changes were going to be made. Other than Bill 184 from 2020-2021, that's the one that brought things out of small claims court back into the RTA, into the LTB. It's the bill that created the one-stop shop for the LTB. Other than that, if you look back at the 27 years since the Tenant Protection Act, which was the predecessor to the RTA, if you look back to the date September 1998, when the Tenant Protection Act came into force, just about every single change has benefited tenants, and this is a rare one. Here's some of the things that have been changed since its introduction. There used to be something called default orders. If the tenant didn't file a written dispute within 5 days, the board canceled the hearing and didn't even have a hearing for rent arrears or for anything else. They created a fourth opportunity for tenants to void a rent eviction. That's the opportunity after it's filed with the sheriff, but before the sheriff has actually enforced the order. They created a right in 2007 for tenants to raise Section 82 issues at a rent arrears hearing without the tenant having filed their own T2, T1, T3, T6, etc., which often resulted in enormous delays for landlords. Because the landlord, if the tenant raises an issue at a hearing, the landlord has a couple of choices. They can say, okay, I'm ready. But the problem is they're often not ready because nobody told them that these issues would be raised. They don't have their witnesses. They don't have their documents. They don't have their reply evidence. So the only thing they can really say to the adjudicator is, I need an adjournment. And the board would grant an adjournment because that's only fair. The tenant raised the issues at the last minute. In effect, they filed a claim without filing a claim, without paying the fee. And the board grants an adjournment, but the adjournment means another 3-month delay. So Section 82 was big, and that was one of the real issues. The RTA instituted orders prohibiting rent increases for certain circumstances for maintenance. Landlords had to provide special forms to new tenants, and also, I don't know what year it was, had to provide energy efficiency and cost info to tenants where the tenant was responsible for paying utilities. There were new rules about under what circumstances a landlord could raise the rent above the guideline for capital expenditures. They narrowed it. And they put in a sunset provision. So after X number of years, you had to reduce the rent back down by the amount that was raised by that specific capital expenditure that had expired. Boy, it's complicated, and mathematically complicated as well. Landlords were required to provide tenants with compensation for landlords' own use applications. We look at that now and we think that's normal, but it wasn't normal. And shortly after that, the change came into effect where landlords had to provide compensation for all other types of no-fault applications, including the applications to evict for purchasers' use. This was an amazing one by Kathleen Wynne. She took out, 2017, she took out the ability of landlords to file an above guideline application when there were extraordinary increases in utility costs. So she left in only extraordinary increases, taxes, realty taxes, or security services. When she was asked, how can you take that out? Utilities are not in the control of the landlord. They're going up like crazy. She said, landlords should buy cost-effective, energy-efficient appliances. But what if the landlord was already buying energy-efficient appliances? It was a terribly political move by Kathleen Wynne, who was struggling to become elected as premier at the time. Corporate landlords, again, Kathleen Wynne, 2017. And many of you may not know this. If you own a property in the name of a corporation, not even partly owned by an individual, you can't evict the tenant with an N12 for landlord's personal use. They expanded the grounds for granting an internal review of the order. They changed the calculation method for above guideline applications. For rent increase. So even if the inflation for that year was 3.9%, the most that the guideline percentage could be for the following year was 2.5%. And finally, they removed and this was 2017 Kathleen Wynne again, they removed the guideline exemption for new builds, although Ford quickly, after the 2018 election, Ford quickly changed that. They drastically increased fines for provincial offenses, for bad faith evictions. They required the standard lease, which didn't help anybody because it made rights and obligations very vague because it didn't include much. They amended a regulation permitting a non-tenant spouse to stay regardless of creditworthiness if their tenant spouse moved out, and they denied any eviction if there was compensation required if the landlord had missed the deadline date, which would have been the termination date. When tenants say, my gosh, this is a war against tenants, it just ain't true. There is push and pull in all legislation. Tension is the nature of rights legislation, and this one just went the other way. And now I'm going to tell you what these changes were. Change number one, I don't even really understand because I don't think it does anything. It simply says that if the act requires a certain notice to be used and the contents of notice, it adds a clause, a phrase that says, unless the form is otherwise prescribed. Well, I don't know what they're thinking. Maybe they're planning something, but it doesn't hurt anybody. I think it just facilitates them doing something that they're planning on doing, and I couldn't figure out what it was. Change number two allows landlords to avoid providing compensation on N12s, but only landlords' own use N12, not purchasers' own use N12s. And that's the new clause. Some people have said to me, well, they've said, can I do it for purchasers' own use? No, it's only for landlord's own use. Second, does that mean I have to give 120-day notice? No, 60 days is still the minimum. But if you decide to give them 120 days, so for instance, today, December 2nd, you give notice for January, February, March, April 30th, that's 138 days or something. If you do that, then you no longer have to pay them compensation. I don't really get it because, and I'm not a landlord, but if I were a landlord and I wanted to move in and I could get the tenant out, I didn't fail in my application. If the board gave me an eviction order, I would not care in the least that I had to pay 1 month's compensation to get rid of the tenant. But anyways, if you give them lots and lots of notice, maybe the logic is they can work a part-time job and 120 days raise the money to pay for first and last. I don't know what the logic is. I think it's sort of foolish. Sense at all doesn't make a difference. But governments do a lot of things that, and they put a lot of things in the RTA that are somewhat misleading because they don't really matter in practice. Change number 3 allows the government to define by regulation what it means to have persistent late payment of rent. So they've changed some wording. They've said a landlord may give a tenant a notice of termination if they've done several things in Section 58, but one of those was if the tenant's been persistently late paying rent. But now they've added a new subsection, says that for the purpose of paragraph 1 of subsection 1, what constitutes persistent late payment of rent will be in the regulations. You know, what does that mean and what's in it? God, I wish I knew. I can't even guess. I mean, I have got some guesses what's in it. Some adjudicators will give an eviction on fewer months late than a different adjudicator. Some will say, well, 12 months at only 2 days a month late isn't so bad, but 4 months at 20 days late is really bad. I have seen a practice started by one adjudicator, and a couple have adopted it, where if a tenant just stops paying, doesn't pay at all, and then the landlord serves an N4 because they owe lots of money, but they also serve an N8, non-voidable, and they go to a hearing, and the adjudicator looks at the N8 notice and says, oh, he's never paid. That's not late payment. That's non-payment. So the adjudicator won't evict on late payment, even though he was 30 days, 60 days, 90 days, 120 days late paying. So I hope they clean up some of that in the regulations. The regulations may be written already, partially written, going to cabinet. Nobody quite knows at this point, but it's a good thing. One of the things that is good about any adjudicative body is consistency of decision making. And one of the worst things about the RTA, the LTB, is there's no consistency of decision making. Change number 4 is a good change. It amends the 14-day voiding period for an N4 notice. It used to be that daily and weekly N4s had a 7-day voiding period, but monthlies had a 14-day voiding period. That means that if you serve the tenant today, the 2nd, and you serve it personally, then the last day for the tenant to pay everything is the 9th, and you can file the application on the 10th. And of course, don't forget, they have to bring the balance to 0 on the date they make the payment. So if you've gone into a new month and they made the payment that was on the N4, but they made it in the new month and they didn't pay for the new month, that doesn't void the notice. So that's how the N4s work, and that doesn't change, except now you can file on the 8th day. You know, it's really not that much because landlords wait for far too long before filing, and that's an issue. It takes 5 months for the process from beginning to end, and you've saved 7 days, that's 4%. So, you know, not like a really big deal, but I'm certainly not complaining about it. Condition number 5 is a little more complex. There are 2 types of applications under the RTA that we call ex parte. That is, in the absence of the other party. One is where you and the tenant sign an agreement, an N11, that the tenant will move out, or the tenant gives you a notice and says, I'm moving out. And the other type of ex parte application and order is when the tenant has been granted relief from eviction at a hearing, either because you agreed or the adjudicator said, I'm not going to evict him, but gave them conditions, payment or conduct conditions, and the tenant breached those payment or conduct conditions, you can file an L4. So the first one's an L3, section 77. The second one's an L4, section 78. I would have preferred this for L4s, but it's not. So it's not nearly as good as it may sound because it's only for L3s. They changed section 77, where it used to say that if a respondent makes a motion under section 77 sub 6, then the board can, after having a hearing, they can refuse to grant the motion. In other words, the tenant's eviction order is still standing, or they can actually grant the tenant's motion, void the eviction order, and the tenant is back in possession and doesn't have to leave. And it used to talk about only that on section 77L3, they could grant the tenant's motion if the tenant actually didn't sign the N9 or N11, or if the member was satisfied that considering all the circumstances, it would be fair not to evict the tenant. It would not be unfair to grant the motion. And boy, that granted a lot of discretion to the adjudicator, because what's fair for Peter is maybe unfair for Mary, adjudicator. And you end up getting inconsistency of decision making. So they took that section out about fairness, and they've simply said, you know what, we're still going to have that section in about you can grant the set-aside motion by the tenant if they haven't received the N9 or N11 and have it signed, or based on conditions that are prescribed in the regulations. That's going to be interesting. What might they say? Well, they might say that if the landlord has signed the new lease, there's no way they can grant the tenant's set-aside motion. They might say that, unless there was misrepresentation by the landlord, the tenant's set-aside motion won't be granted. I hope they have some good things in like that, because now it's just too open-ended where the adjudicator can say, well, I'm going to grant the motion. Too often the tenant files a set-aside motion. I mean, not a lot, but sometimes. And the adjudicator says, well, why should I grant your motion? I've issued the eviction order because You signed the N9 or you signed the N11. I've issued the eviction order. Why should I set it aside? And the tenant simply says, well, I have no place to stay. Well, that will be a thing of the past, I would think, because the regulation will inject some common sense into this, I am certain. Change number 6, the practice of raising any issue at a hearing. It's obviously problematic for a landlord. They did change it a few years ago where landlords would have to be given by the tenant at least 5 days in advance a copy, and there was a special form made up, a copy of the issues the tenant intended to raise, and that was great, and that helped. And I guess what I'm saying is it helped get rid of the frivolous issues. And remember, when you hear tenant groups saying the tenant now has to pay money in to defend their eviction, that is absolutely positively wrong. They don't have to pay money in to defend their eviction. They have to pay money in, or they will have to pay money in, if they want to raise their own application on the spur of the moment without having filed a T2 or a T6 or a T1 or a T3. They always had the right to file that tenant application if there was mold or cockroaches or harassment, or if the landlord's taken away their parking space. They could always do that. And you know what would happen if it went to a rent hearing and then they'd filed their own application 3 weeks ago? Quite likely the adjudicator would have joined them anyways, adjourned everything, and it will come back in 2 months and it would be heard together. So they didn't lose the right to do that. They lost the right to do that at the spur of the moment for no money by raising those issues at the hearing. They can still discuss any defenses they have to the rent issue. The landlord took my money, and now he says he didn't. He demanded cash, and he never gave me a receipt. I paid that money. Those things will still happen at hearings, and as they should. Going to be interesting how the board deals with some of the specifics of the new rule where tenants have to pay some money in, because it does talk about in the statute, in the amendment, that tenants will have to pay 50% of the money prior to the hearing and 50% of the money that's owed. You know, what happens if they gave the landlord a check the day of the hearing? What happens if, they said the check's in the mail? Is the adjudicator going to adjourn it, which is bad for the landlord because that just means delay? Because the adjudicator won't know if that check is going to clear unless they adjourn it. Very unlikely the adjudicator is going to say, I'm going to adjourn it for 7 days, and I'm going to get you guys back here in 7 days and we'll see if it's cleared. I don't know what they're going to do. Nobody knows what they're going to do, but that's going to be an issue. The Act also refers to the tenant having to pay in a percentage of the amount claimed. Well, if the amount claimed is $3,000, but the tenant says that they only owe $1,000 and I can prove it, do they only have to pay 50% of $1,000? Will they get a chance to talk about the fact they don't owe $3,000? These are things adjudicators are going to have to figure out. This change was a little more complex, so I included the entire new section in the PowerPoint. And as you can see, it says that the tenant shall now, which they had to before, give advance notice in accordance with the rules. And the rules say 5 days. But now it also says that unless the regulations provide otherwise, the tenant shall pay the following amounts to the landlord, or if the regulation provides for that, to the board, half of any rent of arrears that's claimed in the application when it was filed, not on the day of the hearing, when it was filed, or such other amounts as may be prescribed. And the amounts have to be paid before the hearing is held in accordance with the regulations. So it's going to be interesting, the amount on the day the application was filed. So if they owed $3,000 on the day the application was filed, and then they owed $6,000 because they didn't pay again, but then the tenant paid $3,000, does that $3,000 get applied to the first $3,000 that was on the application, and therefore they don't owe anything of the money that was on the application? I don't know. It will be interesting to see what other provisions they put in the regulation to tighten that up, and I think that needs a lot of tightening up. Change number 7 allows the government once again through regulation to delay an eviction after the board, to narrow the circumstances on which the board can delay an eviction after the board has made a finding that there are grounds to evict, but has also decided that there's good reason to delay the eviction. As I think all of you know, under Section 83 of the Act, the board has a right to refuse to grant the application or to delay the termination for a period of time. And now they're going to tighten it up because they're going to define in the regulations what specific limitations or conditions apply to the adjudicator delaying termination. This has nothing to do with the board denying termination and limits and conditions on when the board can say, I'm not granting you relief, I'm going to evict. This has to do with when the tenant says, my child is in school, she doesn't finish till June 30th, I want you to extend, or it's an elderly couple and they've been there for 40 years and they need some time and they've applied to a retirement home, or whatever the case may be, and they're asking for an extension of time. And now the board is going to perhaps limit the number of months, maybe, for an extension of time. I can only guess what they're going to do, but rule number 7, change number 7, is going to impose some of those limits. Change number 8, change the board's power to review. Another good change that will speed things up a little bit, and they've done 2 things. Change number 8 requires the adjudicator, once again, to open up the regulations to look at the limits and conditions under which a request to review an order can be granted. It also caps the amount of time at 15 days rather than 30 days for the tenant or the landlord to file the request to review. That's going to do a couple of things. It used to be 30 days. And if a tenant was acting in bad faith, if a tenant was acting badly and trying to game the system, and they were trying to get as much time as they could, they would wait until the 29th day to file the review. Because if you filed the review on the 3rd day, well, now you've lost 26 days that you could have had if you'd filed the review on the 29th day. So now the last day you can file that review is the 15th day. But it does a couple of other things. And remember that this is only for internal reviews, not appeals to divisional court. For those of you not familiar with the internal review process, this board, like most boards, have the right to do a review internally to try to fix their own mistakes so people don't have to go to the Superior Court to have the decision reversed. And in this request to review internally, the board's mandate and power to grant the review is much broader than the court's power to grant an appeal. So the internal review process is the one that's affected by change number 8. Because 2 things. First of all, it's 15 days. Secondly, I don't know what year, maybe 2007, they put a clause in it that said that they added the condition that if the tenant was not reasonably able to participate, the board could grant an internal review. They've removed that. I don't know why, because if a tenant wasn't reasonably able to participate, they're going to grant, or the landlord for that matter, they're going to grant the review otherwise. But now they're going to specifically look at the regulation to see if there are any specific conditions or limitations on granting the review. And I suppose one of those limitations or conditions will be that the party was not reasonably able to participate. There are 7 other substantive changes. 3 of them are already dealt with in terms of landlord-tenant, residential landlord-tenant stuff, but apply also to co-ops. So all the things we've talked about, like persistent late payment of rent, they would deal with that in Section 94.1 for co-ops, but they would call it occupancy fees instead of rent, and they would call it the right to occupy instead of eviction. So those 3 things are duplicates, but for co-ops, and I don't know how many of you, if any of you, really deal with clients who are in co-ops. The other 4 are all technical in nature, and they talk about transition provisions, when these provisions will apply. And it's always tricky because anytime the law changes, you have to look carefully at transition provisions. October 5th of this year, the limitation of the small claims court, and therefore the limitation, the monetary limitation of the LTB, went up to $50,000. So people want to know, does it depend if I filed before October 5th, or does it depend if I had the hearing, after October the 5th. So the same will be true of these changes. People will want to know, particularly as Elaine says, when the hearing could be months after the application is filed, well, does that change apply to me? And those other 4 changes deal specifically with how the issues of retroactivity or application of the new laws apply. And finally, there's one last important provision which talks about when these changes come into force. And it basically says these changes come into force on a day to be named by the Lieutenant Governor in Council, which means the Cabinet. Once they've done that, once they've brought it into force, for most tenants, good or bad, the only downside really is that they may not get compensation if the landlord gave 120 days notice. The other stuff is sort of hyperbole. Yes, they'll have to act quicker, but so will landlords. On reviews, for instance. Yes, there's only 7 days instead of 14, but that doesn't mean you're going to get evicted in 7. It doesn't mean you're going to get evicted any faster, except for maybe 7 days. But when it takes 160 days to get evicted, 7 days doesn't matter all that much. For tenants who aren't acting properly, it means that some of the timelines, and particularly their right to raise those issues, is going to be severely curtailed. For landlords, good or bad, it makes things a little quicker, a little fairer, and some of the adjudication may be a little more consistent. Some of the adjudication may give them more predictable outcomes, and it will take away some of those tools that the tenants used to use if they were acting in bad faith to play out the string. Landlords will have a 7-day quicker eviction, which doesn't mean all that much. The government has a lot of work to do. Regulations may or may not be written at this point. Obviously, they have an idea of what's in the regulations, but they have to finalize those and take them to cabinet. Probably already at this point, it's gone through drafting by the ministry and ministry lawyers. They have to change forms, such as the N4 and the N12. And I know on Bill 184, they took like a year. Some stuff was brought into force in 2020. Some stuff was brought into force in September 2021. Partly, I think, just because they were so slow doing forms, the portal, website update, staff training. I don't know. It was quite amazing how slow they were. Some of the rules of practice directions, interpretation guidelines, a whole bunch of those need to be changed. They have to change their software for the Tribunal Ontario portal. They have to have meetings with staff and adjudicators for training. And of course, the bill, as any bill, can come into force in pieces, so I could be wrong, and part of it could be enforced next week, and some of it not for 6 months. My guess is that it will be 3 or 4 months before it's in force. I just wanted to give myself a brief plug. I do all sorts of training for small landlords, and this is where you can find it. We have videos that can turn landlords into experts. Pre-tenancy stuff, how to stay out of trouble, like rent control, rights and obligations, starting a tenancy, and then what to do if you're in trouble. Evictions for rent arrears, persistent late, tenant conduct, purchaser use, the new post-tenancy claims that started in 2021, attending a hearing, all that stuff. So I keep these really, really up to date, and the videos are usually around 60, 70, 80, 90 minutes with lots of accompanying documents. You can find all these at landlordtraining.ca, and you can be certain that they'll all be updated continuously as these new changes from Bill 60 come into effect. See you next time.